what would happen if at all we are to agree with the submissions of the apparent that the quorum ought to be 3 and not 5. My Lord, currently the IBC has 7 members as constituted today. It therefore means that for any decision that has to be made by the 7 members of the commission, we only need 3 as part of the quorum. That would mean that in any instance, we have 2 members that are making a decision that is going to bind the commission as well as the people of Kenya, because any function and any duty the IBC undertakes is a constitutional obligation that is placed upon it and binds every person, including any Kenyan citizen. Therefore, we submit to say that it could not have been the intention of the legislators that we would have to have a 2-member majority make decisions of the IBC. Basically, that's what it means if we are to stick with a 3-member quorum. In any event, it is not also lost to us that the Isaiah Kibiwott case was not binding on the High Court at the time it was made, because it is a court of concurrent jurisdiction. Neither was it binding on the Court of Appeal. The High Court could and actually did depart from the Isaiah Kibiwott case, and it gave its reasons for doing so. The High Court gave its reasons for departing from the High Court decision in the Isaiah Kibiwott case. It stated the following reasons. Number 1, the High Court stated that the IBC statute did not distinguish between policy and other business. The court, therefore, in departing from the Isaiah Kibiwott case, held that the IBC can conduct its business, cannot conduct its business when its composition is below 5. The duty that was placed before the IBC under Article 257, 4 and 5 to verify and certify that the BBI bill was supported by more than 1 million registered voters was a core business of the IBC, and therefore it required the majority, it required the requisite quorum, which would be 5. Number 2, the High Court considered the question whether or not the BBI bill had met the constitutional requirement for purposes of Article 250. The question whether or not the BBI bill had met the constitutional obligation under Article 257(4) was a very serious obligation and required a number of 5. I've already said that in so doing, the High Court considered the peculiar history that we have in this country as far as it relates to electoral processes, and found that a 5-member commission would, a membership of less than 5 would not be the intention to make such decision, and that quorum was as stated in the Isaiah Kibiwott case, and it is a critical obligation that was placed on the IBC. My Lord, there has been attempts to reduce the quorum from 5 people, 5-member commission. This was done through the amendment bill, the elections laws, the IBC certified that indeed the BBI bill was supported by more than 1 million registered voters. The question therefore before this court, and this court must answer, is what was the effect of the question therefore before this court, and this court must answer, is what was the effect of the declaration of the unconstitutionality that was made in the Katiba Institute case. To answer that question, I would ask the court to find guidance in the Court of Appeal decision in the case of Javan Kiche Otieno, that is in our supplementary band of authorities, which was issued on the 17th of December 2021, a few weeks ago. In that case, the Court of Appeal sat to address a similar issue on what would happen to the original provision of the law when an amendment to that law was declared unconstitutional. In that case, the Otieno case, the court held that at paragraph 46 of that decision, that the inconsistency that the court found to be that the provision, the amendment, was unconstitutional arose from the day that amendment came into force. And therefore, the provision was a nullity from that date and not the judgment date. In short, what the Court of Appeal was finding in that case was to say that the minute that amendment took effect and the court subsequently declared the amendment to be unconstitutional, the unconstitutionality does not arise on the date of the judgment, but on the date the amendment took effect. However, the court also considered the question of what would happen in the intervening period when that amendment was in force. At paragraph 47, the court answered that question, and the court found that the actions that had been taken or uncrystallized when the statute or the amendment was in force were not unconstitutional and could be salvaged and could be held in regard to that. However, most important, in regard to the particular amendment that the court was considering, the court found that once the provision was declared unconstitutional, that provision, that amendment became void from the date of the amendment or the date the amendment took effect. So therefore, we can equally do a comparative analysis. In our submissions, we have referred the court to the position in South Africa, position in Canada on what happens when a statute has been declared unconstitutional, and I believe the court is going to consider that when it retires. However, I would like to, at this point, to refer the court to a South African Constitutional Court decision in the Vin case, where the court found that once a law has been declared to be inconsistent with the Constitution, that law ceases to have any legal consequences. That is what our own Court of Appeal is saying, that once the amendment was declared to be unconstitutional, it ceases to have any legal effect. And then the question is, therefore, what would happen to the original provision? I think that is the issue that this court would address. So once the amendment falls off, what happens? The IBC in this court has submitted that once the amendment falls off, the original amendment, which was the subject of the amendment, is deleted or ceases or equally to have the full force of the law, meaning there would be a lacuna. There would not be any law that governs that particular provision or that particular area that has been declared unconstitutional. So the question then is, or the issue as I understand it, is not the legal effect of the declaration of invalidity, but the effect of the original provision that was the subject of the amendment. We submit that a declaration of unconstitutionality does not affect the original position of the law. Once the declaration has taken effect that the amendment is unconstitutional, then we revert status quo ante, and for a good reason, to prevent a lacuna being there in law. Therefore, in our humble submission, the provision on quorum remained in force as the governing law until either the declaration that set aside that unconstitutionality, invalidity is set aside, or a new law is enacted. However, we are very well aware that any court that sits down to determine or consider the constitutionality of a law has equal powers or has the power to grant an appropriate remedy as far as that declaration is concerned. The court may and has many other times issued prospective or retrospective application of the declaration. At this point, therefore, I will ask the court to look at the orders that were issued in the Katiba Institute case. In that case, the court issued 2 declarations on constitutional validity. It returned a verdict to say the provisions they were unconstitutional and declared them as such. The court did not move further to save that declaration. The court did not suspend the declaration. Unlike the South African Constitution that provides expressly for the power to grant an order of retrospective application or prospective application of the declaration, the Kenyan Constitution does not directly provide for such a relief. We are, however, aware and we are cautious to the fact that the Kenyan Constitution equally provides for the court to grant an appropriate remedy. We therefore submit that the order of prospective or retrospective application was not granted in the Katiba Institute. Such an order would be available right now to the appellants if it was pleaded in the Katiba case. If, even when it was not pleaded, the court granted the order as an appropriate remedy to suspend the declaration of invalidity. And therefore, because the court in that case did not suspend the retrospective or a prospective application, did not find as such, it therefore means that that order is not available in this case at this time. Because they were not granted in the Katiba Institute, this court is not sitting on review of the Katiba Institute case, neither is it sitting on appeal of that decision. So, therefore, the law today as it is on quorum of the IBC is as set out at paragraph 5 of the 2nd schedule of the IBC Act. Interesting, this provision has not been challenged in these proceedings, has been inconsistent with Article 251 of the Constitution, and therefore we urge the court to find that the 2nd schedule on the 2nd schedule to the IBC Act on paragraph 5 that provides for the quorum of IBC has the full legal effect and serves a legitimate purpose in a democratic society. I will now move on to the 2nd issue, which is on the mandate of the IBC and Article 257(4) of the Constitution. Muhuri will address only one aspect of that issue, and it is on the issue of public participation on enactment of the administrative procedures. In this appeal, the IBC contests whether it has an obligation under Article 257(4) of the Constitution to satisfy itself that the promoters of the popular initiative and conducted public participation on the BBI bill before it certifies that under Article 257, 4 and 5 of the Constitution, it had been supported by more than 1 million registered voters. On this issue, we submit that, number one, IBC had an obligation under Article 257, 4 and 5 to satisfy itself that the criteria that was established in Article 257, 4 and 5 was applicable while using the existing laws and guidelines. At this point, I will refer the court to the question that was asked by the Chief Justice yesterday, when she did ask whether or not it is important to have some form of a legal framework that would guide public participation on the mandate of the IBC and Article 257, 4 and 5. We would answer that question, the Chief Justice, and say, at the time the IBC undertook the verification and certification of signatures under Article 257.4, there was no law or any regulations that provided for the actual procedure on how the IBC would do that, including public participation. This finding was made also both by the Court of Appeal and the High Court, and interesting, it has not been challenged in this court. Therefore, in the absence of a regulatory framework, IBC ought to have been guided by the provisions of Article 10 of the Constitution that generally provide for the principle of public participation as a core aspect of governance in this country. The Constitution at Article 257.4 envisages a 3-month window period between which the IBC would undertake its processes under Article 257.4. We of the view that the 3 months period would equally be used by the IBC when undertaking the verification of signatures to grant the public sufficient time to confirm whether or not they had appended their signatures in support of the amendment bill. Such public participation was made to look like it would be so difficult to attain. In our view, we have the view that, as it was in the administrative procedures, that the IBC should provide a process where the public get to confirm indeed to the IBC that if they've appended or they were in support of the bill. They should provide a window period within the 3 months period envisaged in the law for a complaint mechanism, as well as a mechanism to resolve those complaints when they arose. In the instant case, the IBC provided in its administrative procedures that were indeed found unlawful that the public had 22 days through which to verify whether or not they were in support and had provided their signature in support of the bill. However, IBC published the names of those people in its website and provided for 5 days period through which members of the public would indeed confirm to the IBC whether they are in support of the bill or not, and also the 5 days period was also to be a complaint period. The question therefore is, did IBC have a simple, accessible and transparent processes for signature verification that would enhance public participation in the process as envisaged under Article 257.4 and 5? The answer is no. The process was not simple, how the public would get to participate and verify their signatures, because when you go to the IBC website, and this information is on record, IEBC provided a PDF scan. One could not use or search their name or ID number on the website because it was a PDF scan. Even I, as an advocate, we had to spend voluminous time going through the list to indeed look through the list and understand what the IEBC was doing. Number two, the IEBC put this information on its website. Was that accessible to majority of Kenyans? Satisfactorily not. The website stated that the notice to make complaints would be there for 2 weeks. However, the IEBC shortened the period to 5 days. How many Kenyans have access to website and internet in this country? How many are able to go through, have internet, access it, and be able to complain to the IEBC that their names are erroneously put or they did not provide their signatures? How many? Very few can. Was it verifiable? Was it accountable? How the IEBC undertook this? In the absence of a legal framework, in the absence of lawful guidelines and regulations, even we are clear that it also breached its own administrative procedures, who was the IEBC accountable? Can we therefore say that there was public participation in the verification and certification processes as envisaged under Article 257, 4 and 5 of the Constitution? The answer would be no. On the second aspect of public participation, the question then would be, how should it look upon the verification and the certification? On this one, I agree with the submissions that was made by Mr. Ngumbo yesterday, that public participation would arise on 3 instances upon the bill being certified as being supported by 1 million registered voters. The first instance would be at the county assemblies. The county assemblies have an obligation under Article 196(1) of the Constitution to undertake public participation in its legislative mandate. So at the point it is considering the bill, of course, it is envisaged that it would use and would avail the bill for public participation. The question would be, was that done? Public participation is a factual issue. It is an issue that ought to be proven through evidence. The county assemblies are parties in this suit. Unfortunately, they did not participate in the proceedings, and therefore, being a factual issue, it is conclusively to say that there was no public participation at the county assemblies in absence of the requisite evidence. The second instance when public participation would be envisaged is at Parliament, when Parliament is considering the amendment in terms of Article 118 of the Constitution. And equally, at the very end of the process, when the IEBC is undertaking the referendum, that obligation would be in form of civic education on sensitizing the members of the public on the content of the BBI draft bill or any draft bill. We therefore submit to that end that there is a need for legal framework to guide the processes on public participation to ensure that indeed it complies with the IEBC constitutional mandate and obligation, especially while undertaking its verification, certification, and referendum processes. Such a legal framework is very important because it would make the process accountable to the law and therefore be able to ensure that it complies with the Constitution or any other legal framework. Thirdly, we submit that without a legal framework, there exist so many gaps. And one of that gaps is what the Chief Justice did identify: public participation. How is it supposed to be done? Had we had a legal framework, it would be very easy for us to go back to that legal framework and seek whether or not the IBC complied with the law. Indeed, Chief Justice, there have been attempts made by Parliament to legislate on these processes. On record, you'll find 2 bills that are currently pending through Parliament. A casual reading of the 2 bills would provide that indeed at Section 8 and at Section 4, both of the bills provide for public participation. So there is need for a legal framework. There is need for a legal framework to guide how the IBC undertakes its mandate under Article 257, 4 and 5 of the Constitution. Having said that, and having finished what the 2 issues are, I will therefore urge the court not to disturb the order that was issued by the Court of Appeal, Order number 14, that issued a permanent injunction restraining the IBC from undertaking any of the processes under Article 257.4.5. That order has not been appealed, and the issue of an existing legal framework has also not been appealed in this court. We therefore urge the court to affirm the Court of Appeal findings and we dismiss the appeals. We also associate ourselves with the submissions made by the third apparent on the issue of quorum in this court. And that will be all from us. Thank you. I will donate the remaining minutes to the 7th and the 8th respondent. Thank you, Chief Justice.
The donation should be to the 11th and 12th?
Yes.
Thank you very much for your submissions. We will now hear from the 11 and 12 respondents.
May I start? Sorry. May I start?
Proceed.
Thank you so much. It's my pleasure to appear before you, my lady Chief Justice and President of the Supreme Court, and my lords, my ladies, Justices of the Supreme Court. My name is Ongoya. I appear together with Mr. Ogada for the 11th and 12th respondents in the appeal. In our 55 minutes, I will endeavor to use 30 minutes and reserve 25 minutes for my colleague, Mr. Ogada, to deal with the remaining issues that we have organized ourselves to deal with. In terms of filings, I would invite you, in addition to considering the petition number 402 that was before the High Court, to also consider the grounds of objection dated 18th October 2021, as well as our written submissions dated 9th of December 2021, and our case digest and bundle of authorities appearing in 3 volumes dated 22nd December 2021. In the interest of time, I will seek to just draw the court's attention to the following matters that I consider fundamental and overarching as you read those voluminous submissions and authorities. First, my lords, my ladies, we will remind each other that we have a history as a country, and that history has taught us some lessons, some of them very fundamental lessons. Fortunately for us, a bulk of the council appearing at this podium, and my lords, my ladies, seeking to make this monumental determination, you have been a part of that history as citizens of this country. And that we should never let down the generations that will follow us by delivering a verdict that may make generations to come to have to live through some of the pains we have lived through as a country. Part of those pains were captured by retired Justice Aaron Gitonga Ringera in the case of Njoya versus the Attorney General, which you have been referred to, and which I'll implore you to read and have inform your verdict. And to call you to consider that history, my ladies, my lords, is not to invite you to engage in extra-legal considerations. Parliament has done the same thing in Section 3 of the Supreme Court Act. It has asked you that at all times you must endeavor to give us an authoritative and impartial interpretation of this Constitution, and in so doing, to develop jurisprudence that respects that history. Respects that history. So that attempts at clawing back on the Constitution that appear innocuous sometimes, you must be hawk-eyed to see them for what they are, particularly if they are dangerous rodents. Because again, we know that a dangerous rodent will chip away bit by bit, but eventually bring down huge infrastructure. So, in terms of the development of the dispute now before you, I would ask my ladies and my lords to remember that before this dispute was determined by the High Court and eventually the Court of Appeal, there were two advisory opinions that were sought before this court by the county assemblies of Nandi and Kericho and the county governor of Makueni. My lords, my ladies, in your wisdom, and we respect that, you directed that you will not exercise jurisdiction over those opinions to allow this dispute to go through the formal dispute processing mechanisms from the High Court up to the level it has reached. I say that was wise because this dispute has therefore had a benefit of the contribution of dozens of lawyers and a number of persons not formally schooled in legal training, and it has had the benefit of reasoning by a dozen superior court judges, 5 in the High Court and 7 in the Court of Appeal. Without suggesting that you are bound by the decisions of the High Court or the Court of Appeal, I submit that a product of the minds of a dozen superior court justices is not for dismissal by a wave of the hand. It must be taken seriously, and an element of deference must be given to it, so that any disagreement with it must be after serious soul-searching and serious reflections. So that this court, I submit respectfully, should approach the reasoning of the 5 High Court judges and the 7 Court of Appeal judges with a substantial measure of deference. I submit that it's a sound principle of appellate advocacy and appellate judicial decision-making processes that when we're dealing with a second appeal, as is the case here, it is not appropriate to reintroduce and reopen for consideration concurrent factual findings of the Court of First Instance, in this case the High Court, and the Court of First Appeal, in this case the Court of Appeal. If we take that principle in consideration, we then must dispose of some 2 matters with a measure of ease, my lords, my ladies. As a matter of fact, the High Court looked at the evidence before it relating to public participation in the process now before you. The Court of Appeal, as a court of first appeal, had an obligation, and it re-evaluated the material that was before the High Court and came to its own conclusion, and the conclusion was insufficiency of public participation as a matter of fact. I submit respectfully that it is not open for counsel appearing before you or for this court in its decision-making process to reopen that factual issue as to whether there was, in fact, sufficient public participation. As a matter of fact, the High Court, as a court of first instance, and the Court of Appeal exercising that jurisdiction I've alluded to, re-evaluated the question of who initiated this process. And it came to the conclusion that it was the President of the Republic of Kenya who initiated this process. It is not open for this court to reopen that question of fact. And that, therefore, will dispose of a number of questions that have preoccupied the minds of many counsel who have appeared before you today. Having said that, allow me to come to the specific issue that was introduced in the judicial system by the 11th and the 12th respondents now before you, that's Mr. Juma and Mr. Ogola, which led to the order at paragraph 495A Roman 12 of the lead judgment of Justice Musinga, in the terms that the second schedule to the Constitution of Kenya Amendment Bill, and these words are important, my lords, my ladies, insofar as it purports to predetermine the allocation of proposed additional 70 constituencies and to direct the Independent Electoral and Boundaries Commission on its functions of constituency delimitation, is unconstitutional, with one dissent from Lady Justice C. Charlie. That qualification of what was declared unconstitutional is important, and I emphasize it because of the submissions by my very senior learned colleague, Mr. Karori, before you the day before yesterday. The court in fact found that the provision of the Constitution relating to the number of constituencies in Kenya is amendable without necessarily taking recourse to the four-tier process that the court identified. What the court had an issue with was the allocation of the proposed additional 70 constituencies and the direction of the IEBC on its function of constituency delimitation. When you retire to interrogate whether the court was right or wrong on this question, I was warned that when we tell you when you retire, a lot of laymen think that you'll have to wait for your retirement age before you return here with a verdict. So I use that word advisedly in the technical sense of it. It's important for my lords, my ladies, to ask yourself this question: how did the court of first instance reach this conclusion, and how did the court of first appeal confirm this conclusion? A good starting point for me is what the judgment of the court of first instance says at paragraph 469. It's important that you reflect on what that judgment says at 469. And that will be so because the court has to answer the question, did that court use the correct methodology to reach this conclusion? Did it use the correct methods of interpretation? The court said, the stable canon of principles of interpretation of the Constitution, which have emerged as outlined above, are dictated by our constitutional text. So the court took into account the reading of the text. Heavy weather has been made on the argument that this court abandoned the text completely and converted itself into a philosophical tribunal. No, the court expressly said that it is taking account of our text, Secondly, the structure of that text. Thirdly, the nature of that text, which the court defines to mean the fact that it is a transformative charter. Next, our history, which both the Constitution at Articles 259 and 10 and statute, the Supreme Court Act, the very act that now directs this court, and binding precedents and the context. The court is telling us that it is taking on board all material parameters required for the interpretation of this Constitution for purposes of reaching that verdict. I submit respectfully, my lords, that to depart from that verdict, or to invite you to depart from that verdict, the petitioners before you appealing, at least the first and second appellants, had an obligation to demonstrate to you that any of those parameters was an irrelevant consideration. They have not done that. They had an obligation to show you that there was another relevant consideration that those judges were under an obligation to take into account, which they failed to take into account. They have not done that. That then takes us to paragraph 681 of the judgment of the Court of First Instance, which is the High Court. And if you look at paragraph 681, the court engaged in a detailed analysis of the history of Article 89 of the Constitution, which deals with delimitation of constituency boundaries. And the court set out 6 elements in the second schedule, 6 elements that make that second schedule violative of Article 89 of the Constitution. 6 elements. I'll not read them word for word, but you see 6 elements. If you go to paragraph 683 of the judgment, the courts then endeavor to elaborate on each of the 6 elements. I'm submitting, my lords and my ladies, that the High Court, as a court of first instance, used a scientific method of arriving at the conclusion that it arrived at. The jurisprudence, as I know it, is not just enough for you as a court to say, well, on my part, I would have arrived at a different conclusion, and thereby substitute the findings of the High Court with another finding. You would have an obligation to tell us which part of the history as stated by the High Court in those paragraphs is a wrong representation of our history. Not even the appellants have endeavored to point at one. Let me just highlight one example. The court said that a constituency is a unit of resource allocation in this country. The court said so. And the court said, to the extent that a constituency is a unit of resource allocation, the determination of distribution of constituencies has an effect on equity or the skewed nature of distribution of resources. And the court therefore said, to have a scientific and equitable distribution of resources, we must have a scientific distribution of constituencies. The court therefore found that since IEBC in Article 89 is subject to a science of delimitation of boundaries that eventually gives us the placement of constituencies in specific geographical areas, it was not open for us to abandon that and determine constituencies politically, to say it is just a political issue, as my learned colleague, Mr. Karori, has purported to submit before you. Again, I ask the question, Which part of that method of arriving at that decision violates Article 259 on the proper principles of interpretation and Section 3 of the statute enabling this court, the Supreme Court Act, that gives this court a scientific formula of reaching scientific jurisprudence, can you possibly fault? I submit there is none that you can possibly fault. So we are told that if you predetermine the allocation of the constituency per county politically and tell the IEBC, no, your role is now limited to just telling us where this constituency is in Nyamira, where this constituency is in Vihiga, where this constituency is in Samburu, you are hamstringing it from applying the complete methodology set out in Article 89, and to that extent, you are beginning to plant a seed of inequity. You're dealing with a country that has a clear history of inequity. So the court is using the correct formula and saying, no, let the IEBC apply its mandate under Article 89. Use the correct formula, knowing that the IEBC's word in Article 89 is not final. If the IEBC makes an error, there is an avenue available for a disturbed litigant to come to court and seek judicial review under Article 89(10) of the Constitution. The court is saying one of the elements that makes the second schedule unconstitutional is that even that right to come to court and complain by judicial review is taken away. How can we fault the court for such a scientific and principled approach to the resolution of the dispute that was before it? I submit respectfully, my lords, my ladies, that if we apply our minds objectively to the manner in which the High Court reached that verdict and the reasoning that the Court of Appeal engaged in confirming that finding, we will affirm, we reaffirm that finding. We will not disturb it. But more importantly for me, when you retire to have a conversation on this issue, you may also need to ask yourself the question, looking at the material presented before you in terms of the establishment of the task force, the BBI task force, the BBI steering committee, the various reports that they generated, and the publication of this bill, at what stage did the second schedule come into being? That's one question, my lords, my ladies, you will never run away from. Because when you're told there was public participation in even the generation of that schedule, you'll have to answer that question. At what point did the second schedule come in? You will notice that the second schedule was what the High Court judges eventually described as an endeavor to amend the Constitution and fundamentally alter it through stealth, because it's a latecomer in the whole process after the hitherto processes have all been exhausted without anyone telling us. So who was this telling us that Siaya County required this number of constituencies? Who was that among the participating public? To that extent, my lords, my ladies, and so as to invite my learned colleague to engage you in far conceptual matters that are of great impact in this litigation, I submit that once you look at that history, once you look at the relevant materials the judges took into consideration, once you consider Kenya's history as captured in various stages of review of our Constitution, at least in the latter years, partly captured in the Njoya decision and partly captured in the commission reports, including the Kregler report that you have been referred to in depth. And once you look at the BBI process itself as it flew, you will come to the inevitable conclusion that to the extent that the second schedule of that bill purported to predetermine the allocation of the proposed constituencies to respective counties and direct the IEBC on how to delimit those constituencies, that was unconstitutional. But there's an important question that one of my lords raised yesterday, and I've responded to it. When you go to the processing of petition number 402 before the High Court, I want you to investigate the question, what position did the IEBC take on that position? the IEBC, throughout the processing of this dispute up to the time it comes before you, has never contested this position of the 11th and 12th respondents. Never contested that position, that this second schedule is unconstitutional. Number one, I want to look at the appeal that the IEBC filed at the Court of Appeal. They did not challenge this position by the High Court. Number two, I want you to look at the appeal that that was filed on behalf of the IEBC before you. They have not challenged this concurrent finding of law by the High Court and the Court of Appeal. Which brings me to the oral representation by my very good teacher and mentor, Professor Githu Muigai, that the IEBC's position now orally at this podium is that Article 89 of the Constitution does not amount to a basic structure. First, Professor Githu Muigai told us that to him, the word basic structure means entrenched provisions. And he traced those entrenched provisions in Article 255(1). You realize that even if you use that test by Professor Githu Muigai, the independence of the judiciary and the independence of constitutional commissions, which includes the IEBC, would become part of the entrenched provisions. So that applying his own test, Article 89 would become an entrenched position, which he equalizes in terms of effect to a basic structure. And therefore, to the extent that the court at the first instance and at the second instance called it as much, we cannot fault the court for doing that. But more importantly for me, the IEBC must be taken from its word and conduct in the respective courts by its formal findings that it has all along been satisfied by the position taken by the 11th and 12th respondents on the first part, and the position taken by the High Court and the Court of Appeal on the constitutionality of the second schedule of the Constitution. I urge you to dismiss the petition of appeal by the Attorney General. I have reasoned that the Attorney General in this matter was mourning louder than the bereaved, the IEBC, which was the real target of the analysis of Article 89, and we will advise it as much. Allow me at that juncture to invite my colleague, Mr. Ogada, to do duty regarding the other conceptual issues that are relevant to this finding.
Your Ladyship, the Chief Justice, Your Ladyship, the Deputy Chief Justice, Justices of the Supreme Court, my name is Evans Ogada. As a citizen of Kenya, as an advocate of the High Court, I am here to execute duty on behalf of the 11th and 12th respondents, and I will leave to my primary function as an advocate, and that is to speak the constitutional truth and speak the constitutional truth to power. The Constitution, and any constitution for that matter, in its formative force, varies from country to country and from time to time. The French can possibly claim to have been the French and the monarchies and the military dictatorships and assorted republics. The Germans can claim to have been different people under the Kaiser, under the Weimar Republic, under the Third Reich, and under the Federal Republic. For polyglotted societies such as Kenya, and those riven by religious divisions and bleeding memories of civil strife and war, our Constitution assumes an important function. And this function is that the Constitution serves as a uniting force. The only principle of order that there may be, that there may be no other shared moral or social vision other than that of the Constitution. And it's only the Constitution that unites these eclectic societies that we tried to cobble in what Professor P.L.O. Lumumba calls the Berlinian construct, the nation state. The Constitution as a product of the people being the authoritarian creator, the emanator of the Constitution, bears special significance in Kenya in the 21st century. The solemnity of the occasion today for the Supreme Court cannot be overemphasized. The duty of this court cannot be overemphasized. Former Chief Justice of Malawi, Andrew K.C. Nyirenda, in course number 19 of 2020, says that it is the duty of any court to safeguard the purity of the law and to sanction any erosion of violation. That is the duty of the Supreme Court of Kenya. That yours is to ensure that constitutionalism, the rule of law, is maintained and is reified. And what do we mean by constitutionalism? Constitutionalism means that government must be hedged in substantive limits. That there is what is permissible under a constitutional order, even if the perfect majority are against it, even if it upsets majoritarian interests. Alicia Ngoya has spoken about a history, the history of our constitutional journey. The most overlooked part of the Constitution is the preamble. Paragraph 3 of that preamble talks of honoring those who heroically struggled to bring freedom and justice to our land. Justice Muhammad Ibrahim, the victims of the Nyayo Chambers, Nyayo Torture Chambers, Gitobu Imanyara, James Agri Orengo, Maina Kenyati, Baby Pendo, clobbered to death while carried by her mother. These are the matters that we have to remember when you exercise your solemn role in determining this petition. The thrust of the operative legitimacy by the Attorney General and the proponents of the BBI bill is to the effect that the whole exercise was an exercise of amendment. My brother Nelson Harvey and Mutuma referred to you dictionary or definitions for the term amendment. I want to look at the term amendment, Justice Wanjala, from its etymological hasin, the origin of the word. The origin of the word is from the Latin phrase emendere, E-M-E-N-D-E-R-E, which means to correct, to modify a system. An amendment has to operate within a certain parameters of an existing constitution. With regards to boundary delimitation, Article 89(1) identifies 290 units, representative units, and canonizes them as constituencies. Now, these constituencies have been divided within 580,367 square kilometers that geographically is called Kenya. That geographical area enjoys constitutional and international law significance. Under Article 5 of the Constitution of Kenya, the territory is protected. Under Article 2.4 of the UN Charter, that territory is protected. Professor Wanjala, Justice Wanjala, under the principle of uti possidetis juris, international law, we are bound by customary international law to respect those boundaries as bequeathed to us at independence. The Attorney General has two offices within his department, the Kenya International Boundaries Office and the Treaty Division. At independence, when the colonialist was departing, there are certain instruments that were granted to us that clearly behove us to respect this territory. Where am I going with this story? That when the Attorney General, through my learned senior, Mr. Karori, tell us that they are going to create constituencies, that the people can create constituencies outside these parameters, the 580,000 or so square kilometers. The question is this: where is this territory outside 580,000 square kilometers that we are going to create these new constituencies from? Are we going to create them in the air? Are we going to create them below ground? Are we going to create them in the sea? Reductio ad absurdum. It doesn't make sense. The upshot of our argument is this: that any creation of new constituencies can only happen within the demarcated 580,000 square kilometers. And that's where the IEBC comes in. Its role in Article 88 and 89 is to conduct an exercise in delimitation. The Attorney General, through Mr. Karori, waxed lyrical in the defense of the impugned bill, stating that the 70 constituencies were aimed at ensuring fairness and that the allocation of the 70 constituencies was a political role. I shuddered when I heard of the term fairness. The question that the Attorney General must answer before this court is: who determined what is fair? What are these parameters of fairness? And implicit in that argument is the majoritarian representations of the schedules to the BBI bill represents fairness. If we can take it for face value, Nairobi has 12 intended constituencies under the BBI bill. What are you telling my brother from Samburu, Leisagor, Naisula from Samburu? What are you telling Muikali from Machakos? That fairness is synonymous with numbers? Hell no. The Constitution of 2010 has departed from majoritarian premises, and we are saying that we have to be egalitarian. We have to cater for the minority. It is pro those who have been marginalized, and that is the statement of the Constitution 2010. Let us look at the manner in which this bill was originated. It was the position of Senior Counsel Kirago that the origin is hazy. The question is, from their own admission, if this origin was hazy, where did the people come in to prescribe the exact number, that is 70 constituencies? Was the poor peasant, the woman in the village in Yimbo Usenge, consulted in terms of whether she wants a constituency? The people of North Hor constituency, it takes you 5 hours from one corner to another. Embakasi, Babu Owino's constituency, to the Uri's constituency, it takes about 10 minutes. Fairness. What are we talking about when we talk about fairness? What are the impugned provisions of this bill? I'll want to refer the Honorable Court to Section 10 and Section 74 of the BBI bill. What do these impugned provisions do? Number one, they purport to create 70 constituencies. 2, they direct the IBC to determine boundaries and to delimit 70 created constituencies to specific counties, leaving out others. They stipulate the time period within which the IBC must act. They stipulate to the IBC the criteria to be used. Sacrilege, heresy. The IEBC is an independent constitution, enjoying functional independence, and the Supreme Court has addressed itself time and again on the question of independence. I refer this court to the decision of matter of interim Independent Electoral Commission, advisory number 2 of 2011. I also refer this court to the Communications Commission of Kenya and 5 others versus Royal Media, 2014 EKLR. The court spoke of independence, and I'll refer you to exactly what this court said. You cannot depart from that. For purposes of rule of law and for certainty, I beseech you to maintain the statement on constitutional commission independence. There was a position held here by Mr. Karori on behalf of the Attorney General that we are still in the conceptual mooring of 3 branches of government. May I correct that assertion loudly and clearly in the presence of my teacher sitting on the other side, Professor Ben Murumbi Sihanya, that we have since moved from the traditional understanding of government as 3 branches. We have moved from the trias political model, and with the commissions, the independent commissions coming in, that is argued, amongst others by Professor Sihanya, that we have a 4th arm of government, so that when Justice, the Deputy Chief Justice and the Chief Justice represent the Supreme Court at the Judicial Service Commission as commissioners, their presence there is in an independent office, contradistinguished from the judiciary, where they sit as judges of the Supreme Court. Power contrary to contra-power, ambition contra-ambition. That is the Montesquieu edict in terms of separation of powers. So that when the IBC is a beneficiary of separated power, its functional capacity under Article 88 and 89 must be respected, and without apologies. What is the mischief that was intended by the Constitution in terms of demarcation and delimitation? There are certain undergirding principles that were intended to be safeguarded. And these principles we have highlighted, and I refer the courts to volume 3 of our case digest, from page 450 onwards. There's a scholarly article by a lady, Lisa Handley, giving a history of boundary delimitation from a comparative perspective. The history has been looked at by the High Court. The principles: impartiality, equality, representativeness, non-discrimination, transparency. I will address myself to the question of impartiality, because that is what concerns us with the IBC. The process of boundary delimitation is removed from the political organs, and the IEBC should shepherd the whole process and guide the people in terms of the whole process. Elisha Ngoya has gone through that process. I will not go through it. But if the people were to be aggrieved by the processes conducted by the IEBC in creating new constituencies, then we have a recourse to Article 8910. What this bill in its purport tries to do is to short-circuit the Constitution, to remove the ability of the people to seek redress from the judiciary. The manner in which they propose for this new creation of constituencies to come in is what we call in conceptual theory constitutional octroi. What is constitutional octroi? An imposition, a patrimonial way of creating a constitution. thesis to what we have under the Constitution 2010. Ours is a liberal democratic manner in which we generated our Constitution. And it is important to know that the people, in terms of creating these new constituencies, must influence the role, must have an influensive role through public participation. Public participation is important for this reason, that conceptually, we are trying to take away imposition by politicians, and the people must qualitatively and quantitatively have an influence with regards to decisions that affect them. Constitutional octroi, as being suggested by the Attorney General, is a seeping, an insidious threat to constitutionalism. That should it be allowed, and bearing in mind our history, our constitutional history, we will be inviting the insidious tarantula effect, whereby politicians can creep in and massacre, butcher, murder the Constitution as we know it. It must be resisted. The judiciary as a negative legislator. A question was posed here in terms of the judicial role. The judiciary is a negative legislator, so that when the courts correct misgivings or errors in accordance to the Constitution, the judiciary becomes a negative legislator. It is a proper function for a Kelsenian court. So that this court is besought not to be afraid to dabble into what will otherwise be termed political. Because I had the term political being bandied around here. This court should take safeguard and safety in the Indian case of the state of Rajasthan and others versus Union of India, 1977, where the Supreme Court of India, Bhagwati Jay, said that the Constitution is a matter of politics. So that Justice Ibrahim, when you deal with the constitutional question, this is an essentially political question. You cannot be intimidated into handling it as if politics is the preserve of politicians who think cyclically in terms of 5 years and think about their partisan interests. You, as lawyers, are trained to think in terms of posterity, in terms of our life, our collective life as a country. You, as of necessity, must deal with the question. In conclusion, Chief Justice, in 1803, on a cold, frigid morning of February the 10th, 45-year-old Justice John Marshall and his colleagues in the American Supreme Court, dealing with the question of appointment of magistrates through commissions, made a tectonic statement. It is inherently the province of the judicial branch to state what the law is. The tectonic effect of Madison versus Marbury, which was decided on this day, reverberated all over the world. And the province of judicial review, as we know it, owes its life to this momentous day. The Supreme Court sits on the crest of such a moment. You are being requested to make an intellectually sound and bold decision. We know that you're equal to the task. The country is looking up to you as the Supreme Court. And this court owes the country a duty to do what is right. Equality, justice must prevail. The rule of law. Justice Ouko, that poor child in Maryland will expect you to make a definitive statement that when he or she appears for a public job interview, he or she will not be sacrificed for the reasons of her ethnicity or for the reasons that her father or mother has a small name. In your quest to find judicial truth, we pray that this court remains alive to the history, our history motleyed by corruption, nepotism, malgovernance. The court is besotted to remember our constitutional history and the price that was paid by martyrs who along the way shed blood, the seed of our constitutionalism. Writ large, our national sanity, our joie de vivre has been replenished and remains alive due to a bold judiciary. And every time this court has made bold decisions, our spirit de corps as a country is always reflected. We are happy because from the gloom and misery that we have been subjected by politicians, the courts have displayed sparks of life. And this court will have the occasion to do it again. Please do it again. Do not be afraid. And Justice Patrick Omwenga Kiage, Lord Justice of the Supreme Court, of the Court of Appeal, says that the judge under the Constitution 2010 is a lion or a lioness. You are expected to roar the constitutional truth. You are expected to say it like it is. I have recourse in conclusion to a very noble son of Africa whose text I carry in my hand, and that is Justice Digeng Moseneke, retired Chief Justice of Deputy Chief Justice of this South African Constitutional Court, Professor, University of Pretoria, who says in his book, All Rise, a Judicial Memoir, at page 305 thus: fidelity to our oath of office is important, not because we are important, but without it, it is not us, but our people who will suffer. By our people, I mean the full diversity, poor and rich, white and black, female and male, urban and rural, the marginalized and powerful, all deserve our unwavering protection, which our Constitution demands us to provide. After all, you are the ultimate guardians of our Constitution, for and on behalf of our people. That maxim, that edict by Justice Patrick Omwenga Kiage, the judge under the Constitution 2010, is a lion or lioness. Go ye forth and roar. Roar. Let every corner of this country hear the roar from this court. We submit that all the appeals as standard be dismissed in their totality. Thank you.
Thank you very much, Counsel, for the submissions. We will now hear submissions by the last respondent, Kituo Sacheria 79th respondent.
My humble apologies, Your Ladyship. The 4 minutes will be donated to Kituo Sacheria.
Honorable Chief Justice, Dr. Camino is taking a health break. I think he'll be here in the next 1 minute.
We can take ours. In that case, then as we wait for Dr. Kamino, we will also take a break up to 11.